Nicolas Petit, welcome to Digital Markets Research Hub. Thank you very much for your availability. It's a great pleasure to meeting you. My first question, and I have many, is related or is an invitation to do an impossible task, to provide your outline of the extremely busy, extremely condensed, extremely kaleidoscopic development of competition law in the previous couple of years, and it looks that we are at some bifurcation point where either the pendulum, if we are talking about pendulous relationship, is swinging backward, or something important is happening. And in these moments of time, it's necessary for us to share the views and to learn about the views of people who shape and understand the development of our field best. So let me invite you to provide your projection of the evolution of competition law, maybe looking also at digital markets or maybe separately in the previous few years, and where does it lead us?
Okay, thanks, Salesh. It's great to be with you today. So look, I don't have a very spectacular prediction to make about the state of the field today and where it's going to go in the near term. I can tell you where it's not going to go, I think, and maybe I can conjecture what is going on today in the US and in the EU. Okay, so where it's not going to go is I don't think we are going to see any form of leap to the kind of novel and uncharted territories that the neo-Brandeisian school wanted antitrust to go into. And this was a sure thing in Europe, that Europe would never embrace this sort of, more political antitrust and more distribution-based antitrust. But it's very clear that in the US, this is not going to happen. And in the US, this is not going to happen. So the sort of, okay, let's make political antitrust a reality, or let's make antitrust political again, and let's talk about threats to democracy and this and that. I think this is not going to go anywhere in the US and in Europe. In the US, the antitrust is going to become more political, but not more political per se. It's going to become more politicized. And it is going to be used as a weapon for political influence by the Trump administration, which is probably going to try to enforce antitrust law to achieve very discrete and tactical political objectives. In Europe, by contrast, the focus has gone from a very open-ended discussion on the goals of antitrust, whether we should include additional policy preferences such as the protection of the environment or the protection of privacy. And that window of openness of competition law to external goals, I think, is closing in favor of one key goal, which has always been the goal of competition policy, which is to promote increases in output, growth of the economy, and long-term prosperity, right? And the proxy for that is innovation, but innovation was always sort of baked in. I think now it's going to be prioritized a little more. So I think in the US, we're not going to see the political antitrust of the neo-Brandeisians. We're going to see politicized antitrust. In the EU, we're not going to see green antitrust or privacy antitrust. We're going to see growth-oriented antitrust, which was always baked in the antitrust system since the SPAC report and since actually you could say the founding treaties of the European Economic Community. So that's interesting. And so now what's going to happen, I think, and what we are seeing here is that we're still seeing the sort of byproducts of the previous 5 years having influence in antitrust, and maybe this is going to last. And this byproduct is that I think in both the US and the EU, the agencies and maybe the courts will be more daring in terms of enforcing antitrust rules, Article 101, 102, Section 1, Section 2, and the merger prohibitions. And by that, I mean that if one thing has been achieved by the discussion these past few years, it's not the big goals that the neo-Brandeisian schools or the more open-ended antitrust movements wanted. It's not that, but what will be achieved in the short term is a more active enforcement policy, right? So at the technical level, it is more readily admitted that the agencies, in a context of uncertainty, can step in to apply antitrust law. It is more readily accepted that the burdens in the proof of antitrust infringement and efficiencies need to be slightly recalibrated to allow the agencies to do a little more, to be a little more, to be a little less precise and a little less determinate in their theories of harm. And so I think we're still going to see that, right? So we have all these discussions about burdens of proof. We have all these discussions about structural presumptions. And so I think this movement towards maybe a more daring antitrust program are the byproducts of the past 5 years, right? And for me, the question will be, given all the challenges in Europe, for instance, with the Draghi report, that calls probably for, I think, a laxer antitrust enforcement policy against consolidation, so a less strict policy against consolidation. We shall see whether this more daring attitude that the enforcers have, this more confidence, self-confidence attitude that we can see in the agencies in the US and in Europe, we can see whether this will stay or this will be moderated by the force of this big policy call for a more consolidation-friendly antitrust and merger policy, at least in Europe. I hope that's clear.
That's clear in terms of the implications, but I wanted to ask two clarificatory kind of benchmarks for you, to invite you to highlight two or range state, because you have said at least about the first one, namely political antitrust and politicized antitrust. I think it's very important to make this distinction. So if you could elaborate it a little more on the differences between two. And the second one, when you talk about competition policy, do you use the vocabulary of antitrust intentionally? Do you leave aside quasi or proto competition policy, namely the more proactive, sui generis Digital Markets Act like instruments? So these are two clarificatory questions. And about Let and Draghi report, maybe I'll ask separately. So political, politicized, and B, do you talk about competition policy sensu lato or sensu stricto?
Okay, so the term political antitrust is a very bad term as a matter of principle. This is a bad term because the term political is an empty concept. Everything is political, nothing is political. And so it's a nice, catchy title, sentence, or slogan, but it's a very meaningless concept. Politicized is better because politicized refers to the weaponization of antitrust law or any other body of law to achieve party politics, to perform party politics program, to achieve tactical political objectives in the political sphere, right? So you can see that with what's going on in the US today. The Trump administration wants retribution against the communications technologies that have allegedly discriminated against certain types of political views on social media and other types of platforms. And now, the instruction or maybe the ambition of certain people in the administration would be to use antitrust to censor or punish firms that have engaged into that alleged discriminatory behavior. That is politicized antitrust. I think when people think about political antitrust in the other possible meaning, what they mean is a more neutral usage of antitrust law to achieve what people in Europe would call constitutional objectives, such as, maintaining a balance of power in society, and especially in markets, between suppliers and buyers, between the private and the public sector, between the public sector and the citizens, between the private sector and the citizens. So that is a nice idea, but it's a very high level idea. There are many ways in which you can organize a program of political antitrust. So I think what today people have in mind when they speak about political antitrust is this big power thing. Oh, antitrust is a bound on power, right? As Giuliano Amato used to say, he wrote a book on that. But, again, power is a very imperfect concept because there is power everywhere in society, right? So you cannot define antitrust as an instrument to rein in power. I mean, what power are you talking about? And so there are many ways in which you would administer a political antitrust program that is designed to moderate power. So you can think about, of course, today we speak about the power of the private sector against, I would say, maybe the state. I want to open the question here, which of the private sector or the public sector has more power in a country like the US today, where you see that all the big Main Street and Wall Street CEOs are going to bend the knee at the White House. Who has the power, and what kind of power should antitrust concern itself with? Is a big question. Should it protect citizens and consumers against the power of the states that can capture private interest, or should it protect citizens and consumers against private power, and private power where? So people have views about this, but I don't think talking about political antitrust is doing a service to the profession, because there is no functional objective behind slogans like political antitrust. Of course, it's about power. What kind of power? So I don't like these big terms because I think they are, let me add something here. I think the people that get too hyped by these things tend to stop at this stage, right? They talk about political antitrust and they stop there. And then there's never a really clear, actionable course of action for the application of the law behind these big slogans. So it's lazy to talk about political antitrust. It's too lazy. And I don't consider myself a lazy person. The people that know me don't consider myself a lazy person. And I don't like to be lazy with my brain, I think. So maybe I'm not, yeah. So, I mean, it could sound a bit arrogant, but it's not the case. It's just that I don't find enough answers. As academics, we want to find answers to things, right? We want to ask the right questions, and we want to provide the right answers. And I think this political thing is just it's just such a convenient excuse to stop thinking, right? I don't like it.
And on the definitions of competition policy, do you include the proactive tools as well?
Yeah, so I believe that there's more than one tool that you can implement to protect or promote or maintain competition in the economy. So all these instruments deserve to be brought into the box of what we call competition policy. And there's a lot of work that needs to be done through other mechanisms than the rules on anti-competitive agreements, the rules on anti-competitive abuses, the rules on anti-competitive mergers. While in Europe we know this, I mean, we have the state aid regime. We also have the FSR now, which is in a way a competition policy tool. We have the DMA, which is a competition policy tool. The DMA is a sector-specific asymmetrical competition policy regime. So all these things are competition policy instruments.
Okay, so do you think as a citizen, as as a kind of part and parcel of European civilization, that in the 21st century, the position of Europe in the area of digital markets or digital technology is satisfactory, that we are not lagging behind the global top tier entities, political entities or groups, and that if the gap exists, will it increase further with this kind of rapid, fast development in other parts of the world and slightly slower development in Europe? And if this diagnosis is correct or partially correct, so is your answer that competition law is not fit for this, and it can only be politicized occasionally if you know what you want? So how, to cut the long story short, to rephrase my question, what should Europe be doing? Should we just enforce obediently the glossas of competition law as we knew it in the past? Or is it a recipe? Is it a remedy for us to advance further? Or we have to do something else, but it has nothing to do with competition policy? Please provide your explanation.
Yeah. Okay. So thanks, Alex. So I think competition policy in Europe is a symptom of a bigger problem. So it is not the culprit of Europe lagging behind in all things digital and so on and so forth. So I am completely in agreement with a lot of people in the competition community that it would be unfair to assign all the blame to competition policy in Europe for the dire state of affairs that Mario Draghi described in his report in the fall last year. So competition policy doesn't deserve to be the main scapegoat for that state of affairs. Now, at the same time, it would be unfair not to acknowledge that competition policy plays a role in this, all the more given that competition policy is, as we know, one of the main and only policy that the EU enjoys to achieve outcomes in the European and global economy. And so it would be a bit foolish now that we've spent 60 years telling ourselves and actually acting on these motivational calls to say that competition policy is irrelevant in the state of affairs in which we are. I mean, we've heard for many years that we have the best competition policy in the world, that we enforce competition policy way more than the Americans, for instance, and that our levels of enforcement are good. The Philippon book a few years ago was all about this, was all about, oh, look at how the Americans are fully enforcing their antitrust regime, and how we in Europe, we should be proud because we have, lower prices in telecoms and so on and so forth. And this is the contribution of competition policy. So we cannot read the Draghi report and say, hey, competition policy has no role in this, after having spent 20 or more years saying, well, look how good we're doing with competition policy. I think what the Draghi report shows is that there has been no concrete engagement with the assessment of the effectiveness of what we were doing with competition policy, right? And the question mark is still open here. Actually, DG Comp released a report on the state of affairs in a variety of European markets a few weeks, I think, or months before the Draghi report. And this report was saying something that I think should be read as, a little bit embarrassing, actually, for the competition policy enforcement community. And it is that, market power has risen and markups have grown across industries. And if that is the case, and if that is true, but if it's equally true that we have enforced European competition law in a good way, well, then, the question is, it's been very ineffective. I mean, the main hypothesis you should have is our enforcement has either been counterproductive or irrelevant, right? And this is a logical deduction that you have to make. And so from there, if these two propositions, and they are the only logical propositions with which you can work together through the Draghi state of affairs and the DG Comp state of affairs, then the way forward is certainly not to say we should double down on everything we've done in the past, right? So more enforcement, more structural presumptions, more of what we've done. I mean, the presumption should be against more of what we've done, right? And then the hard question becomes, okay, so what should we do with these tools, right? What is it that we should do differently? It's not the issue is not let's do nothing, right? Because you always have the possible conjecture that, with less enforcement, if the market power that we see in the data would have been higher, right? But I mean, this is a hard thing to prove, so I would not start from there. But so it brings to the fore the question, okay, of what should we do with competition policy? How should we redirect competition policy on the understanding that its role is not the main role in the innovation lag that we have, but it has a role to play, right? And so I think Draghi is, spot on a number of things. I can talk about this if you want. But so, one of the main messages in the Draghi report, and I don't think people understand, people in the competition community often do not want to hear this because it's difficult, but it is something we can square. One of the main messages is we need more consolidation in Europe. There's not enough consolidation in a lot of European markets. And we need to adjust the policy tool that we have to relax the constraints on consolidation. So when Draghi talks about merger policy and he says that we need an efficiency defense, an innovation defense, we need a better efficiency defense, he's not necessarily saying that we need to stop prohibiting mergers, right? What he's saying, and people do not necessarily read this, I don't understand why. What he's saying is, in merger policy, the standard approach to a potentially problematic merger is to negotiate a divestiture. There is this divestiture culture. So, the intervention rate in mergers is, you could say between 8 and 15%, give or take. And sometimes, divestitures will be even asked or proposed in a lot of other cases that don't raise, serious doubts, don't go to phase 2. So you have a lot of cases in merger practice that end up, even if they're relatively minor in terms of their competitive consequences, that lead to divestitures, either in the formal proceedings or sometimes before. So that's divestiture. Draghi says that divestiture culture, that sort of systematic approach that leads to review mergers on the understanding that there will be a divestiture, that needs to change. A merger doesn't need to come with a divestiture built in to be approved. We should stop with this. And because by having this obsession with divestiture, we are preventing consolidation. We are making it slower. And we do not have the luxury of this. So I think Draghi is saying that, and that's why he's saying also, so the sort of, the other side of the coin is to say, instead of going through this structural approach for every and any merger that raises some competitive concern, we should instead have this ex post approach, which is to say, let's put the divestitures off the table and bring me a credible case that post-merger you're going to make the necessary investments, right? So the trust and the trust of the trust dynamic has to change, right? I don't need you to cut your arm in front of me, so I trust you. I just need you to tell me that you're going to take medicine exposed so that we see this efficiency, right? I think that's a much better approach to solve the concern that we discussed before, right? It's a nice way to redirect a little bit how we do competition policy in a technical way, and one that meets the concern that indeed European companies, European firms are too small.
But isn't it the case that in both of their reports, primarily in Draghi's report, but also in the latter report, they somehow add another dimension, namely geographical dimension, that somehow propose or suggest inferring a differentiated treatment in a sense that consolidation is needed, but if we approve consolidation of undertakings coming from other jurisdictions, it is a kind of zero sum, particularly in markets like telecommunication, when they've both been more wider reflecting upon the state of affair. How do you position the role of this zero sumness? So that you have to be more lenient towards European companies, but more diligent and more demanding vis-a-vis foreign consolidations?
Okay, so I think there are two angles to this. The first one is it's not just about being more lenient towards European firms versus non-European firms. It's to be more lenient towards pan-European transactions versus non-pan-European transactions. So transactions that involve only external players or transactions that don't involve only national players together, right? I don't think Draghi wants that. If Draghi wants a reconfiguration of the telecoms industry, he wants to see a state of affairs which is today where we have more than 20 telecom players across Europe, with like 4 in every market, to a reconfiguration in which we have 4 pan-European telecom players in Europe, right? That are, that would be almost the same in every market, national market. And so I think Draghi would like to see a reconfiguration in which, the main Belgian telecom player would merge with the main Italian telecom player to create this. He doesn't necessarily wants to see a reduction in the number of suppliers at the national level. What he wants to see is a reconfiguration in the identity of these suppliers across trans-European lines, right? So I think that's what he wants to see. The second thing that's interesting, and I think this would be a hard case to, and these are the kinds of questions you'd like to ask to people in the DG Comp and people in the academy, in the Competition Economics and Legal Academy, is, what should we do if tomorrow a company like Google decides to acquire Mistral, right? The main European large language model AI provider, right? Should we allow Google to buy Mistral? Or, given the intense competition there is, there's no clear case of a horizontal harm to competition in a transaction like this, right? There's lots of competition. Google is probably not number 1 in that space. But at the same time, if Mistral ends up being controlled by an American company, you don't have certainty that the headquarters, the R&D will stay in Europe, right? And I think on that, I have a very different take from a lot of people in the field. I think we should prohibit that kind of transaction. And I should say that, for me, it's a very clear case in which, the merger regulation could be used to do that. And the reason is not just the fancy today, but, the sort of old fancy, French industrial policy Colbertist approach. It's more related to the state of knowledge in economics that we have. So there are very serious studies, very sophisticated studies actually, that show extremely well that the innovation spillovers that you get for R&D cluster geographically. So the other way to put this is that ideas do not travel well with distance. So if you want to maintain a degree of innovation activity in Europe, and you would want to do that because there is a very clear correlation between the geographical location of innovation and the long-term levels of prosperity that you have in an economy. I mean, this is why Draghi is saying, we need to catch up in Europe, right? Because if there was if geography didn't matter, it wouldn't matter that all the tech firms are in the Silicon Valley, right? And Trump or Biden would not care if Google and all the other companies migrated outside of the United States, right? If there was no relevance to geography matters. And the reason is that the returns on education, the returns on prosperity from innovation cluster geographically, and the innovation activity clusters with where firms locate their R&D activities, their innovation activities, right? So if you have a large R&D facility in Paris, it's a very clear prediction from economic theory that your innovation activity in the surroundings of Paris will be higher, for instance, than in the surroundings of Marseille or in the surroundings of Florence. And, I mean, the anecdotal evidence is clear, it's also a reason why a lot of people are engaged in trying to attract these companies to invest somewhere, right? So if you had a merger between Google and Mistral, a takeover of Mistral by Google, the approach would be, you probably would say from an innovation standpoint, if you're interested in, harm to long-term innovation, has a theory of liability for competition law. So you have a transaction that's going to reduce the number of players in an industry, and it will have an impact on long-term innovation, in turn stifling, reducing competition and long-term competition again. You can make the case against a Google Mistral takeover, and I think then the question could be whether you want to condition that transaction to a remedy which would involve a promise from the buyer to keep the innovation bases, the innovation labs on the European territory. That could be something that you would like to negotiate with the parties.
But this leads us to the issue of prudent and kind of omnipotent enforcement. So what is the role of the Commission, let's say, in this constellation? Because it appears that they have to exercise their discretion, their political wisdom, in order to see which transactions, how to tailor the consequences, how to instrumentalize merger policy, and I imagine for this purposes also the DMA, the enforcement of the DMA, in order to achieve something which is strategically in the interests of Europe, let's say in the interests of European innovation environment. If this is the case, does this model presuppose a Leviathan, an omnipotent enforcer with demiurgical power and wisdom, which would somehow in a dirigistic fashion decide which transactions are for the greater good of this polity and which should be more scrutinized with greater diligence? And if this is the case, how it can be consolidated with our kind of democratic perception of governance? Please bring some order here or clarity.
Thanks, Alesh. So I'm a big fan of using economics to cabin the discretion of, as you say, omnipotence enforcers of the law. And in competition policy, the scenario that I was just mentioning, Google buying Mistral, is something that could be reasoned and rationalized and based on a very clean economic set of considerations that should be explained from the get-go, and that would then direct evolutions in competition and merger policy norms. So I I would not like the European Commission or any other agency to pick up the mergers with a home company it likes and those that it doesn't like. I would like this to be based, to be principled and to be guided by a rule. And I think the rule needs to be established and built on the basis of what we know from economics, which is that the returns to innovation correlate with the geographical situation of R&D labs or other types of innovative business units, right? By contrast, innovation doesn't really correlate with the location of headquarters, for instance. We know that, right? So it would make no sense. It would make so if company A from America buys company B from Europe and company B from Europe doesn't have a lot of R&D activity in Europe, the R&D activity is elsewhere, in China, I don't know, wherever. That is not a concern for innovation because, it's going to buy, mostly the cost centers of that company in Europe, and it's going to, of course, buy the shares and all this and that, but there's no tangible impact on innovation. By contrast, if company A buys company B that has substantial R&D presence in Europe, well, that is something that should be a concern. And this is, I'm not the one saying this. Empirical economic studies have been saying this. The question is, you want competition agencies to read that literature and to derive from that some prescriptions about the limits to extremely discretionary intervention. And that's where I set myself apart from all this discussion about industrial policy. I think there's a way to do that doesn't, so, oftentimes when you say something like this, people say, oh, this is industrial policy. No, it's not industrial policy. It's careful economics.
So if you have a dialogue with, let's say, gatekeepers, when you talk about digital markets, do you see the room for collaborative, participatory approach where the Commission can show their power without enforcing it excessively or too enthusiastically? And the gatekeepers can somehow say, what do you want? Do you want us to invest more in Europe? Do you want us to keep European innovation in Europe because geography matters? And we can somehow tailor our policy and our strategy of growth, factoring in the specificity of Europe, because it's not the market which we can ignore, and it's better to do in collaborative and not non-antagonistic fashion. Do you think there is a room for such kind of dialogue or multi-logue between the enforcer and the regulatees? And if yes, doesn't it again presuppose a kind of demiurgical strategic vision rather than short-term electoral cycle oriented or embedded philosophy, regulatory philosophy on the side of the European power, let's say?
I think it's been a bit unfortunate that all this language that has been used these past few years in Europe in relation to digital consisted in rhetorical devices trying to oppose certain types of business organizations against the public interest. And again, I want to go to Draghi here. So Draghi is essentially saying that Europe is stuck in bad equilibrium where most of its economy is composed of low to mid-tech firms in sectors which do not find enough returns from investments into innovation. And therefore, innovation doesn't diffuse in the European economy, and especially digital doesn't diffuse in the digital economy. Draghi is telling us that Europe and Europeans, I think actually Europe and Europeans are different here. I think Europe has decided as a policy attitude to be very antagonistic to the digital economy in general. this has been a very irresponsible attitude if you read the Draghi report, because by convincing themselves that the digital economy is a broken segment of the broader economy, the typical reaction in Brussels has often been, we need to control this with rules. We need to put more guardrails on all of this, not realizing that the relationship, so not realizing that first, this segment of the economy is the most conducive to growth and prosperity today. Second, by creating the idea in Europe with all its low and mid-tech firms that they should not necessarily try to be entrepreneurial in relation to digital, but that things would come from rules and legal remedies. Three, by creating a sentiment of general hostility towards digital, whereas this is the only thing that can get us out of, the dire situation in which we are today. I mean, the prosperity gains will not be achieved by demography, as we know, or by longer working hours, because no one wants to work more in Europe. And so this language has, I think, and this attitude has been extremely nefarious, and we see that in the Draghi report. Now, the problem that I find is that today, this regulation, the DMA, is a good example of this. It's not realizing that the relationship between big tech and other companies, small tech and mid tech, is a very symbiotic relationship and has always been. I mean, these firms did not build themselves alone. When we speak about ecosystem, what we should start from a basis in which we understand that cooperation is the norm in digital. There's gigantic cooperation between large tech firms, mid-sized tech firms, and small-sized tech firms. So this old notion that they are the big tech players versus the rest of the digital economy and the economy in general is a figment of one's imagination, and we need to remove this. I mean, we need to remove this. Big tech has been an opportunity for a lot of people. I don't know if you have friends that work in digital advertisement. I don't know if you have friends that work in search engine optimization. I have friends that work in these industries, and these people 15 years ago were working for law firms, and they got tired of working for law firms, and they wanted to reinvent themselves. So they started to play with digital, and at least two of my good friends have small digital advertisement agencies, and they like their jobs. And none of this would have been possible without the large tech companies and the firms that are around, right? And so, of course, in some specific segments of their activity, there are some things that are not great, right? But most of this could have been dealt with under the traditional competition rules. No, but instead, we decided we had to go wholesale and have, a regulation that would create these lines of business restrictions that would raise the cost of cooperation between large and smaller companies. That would lead to increased friction for consumers on the idea that by creating friction, you're going to incentivize switching. That would raise the cost of new service launch in Europe. I mean, I'm very tough on the DMA because up to today, the DMA has not articulated any coherent, explicit, and rational vision of what it's trying to achieve. It's just a piece of legislation that is applied in a sort of almost automatic way without any definition of what we want to achieve in 5 years. what is the outcome on which we can evaluate the DMA in 5 years? What will be the outcome or the outcomes? No one speaks about this, right? And so what I want to convey here is, to your question is, I think we've shot ourselves in the foot with this language on digital. And the DMA and other pieces of regulation are a little bit the manifestations of this. And until we define we refine the vision to something that is not antagonistic and something that is manageable and doable and that makes sense, I don't think we are going to make a lot of progress here.
Let us now move to your from the strategic thinking to your research incarnation dimension. And let me invite you, please, to highlight the main research trajectories which you've been either accomplished recently or you are currently in the process of exploring. Some are related to consumer welfare, the role of consumer welfare, others related to the role of complexity, to the area of complexity economics. And they are united in this kind of umbrella initiative, dynamic competition initiative. Please put these jigsaw puzzles together.
Okay, so like I said before, I think my research, I work on my research a little bit like a venture capitalist, right? So I have like 25 projects, and the reason I do that is that I can get bored very quickly, and so it's always good to have another project that you can go to, so you don't get bored, right? So the downside, of course, is that all these projects do not progress very fast, and the other downside that sometimes people fail to understand what you're doing or who you are. But I'm not really worried or interested in that last point. I mean, this is not something that has a huge influence on me. So I have these 25 projects, say, and depending on the circumstances around me and my co-writers and what I want to do, I accelerate on some, I slow down on others, and this and that, right? So in addition to this, so this is my daily, the desk situation on a daily basis, this, right? So if you come to my office, you'll see all the mess and projects. And so that's the state of affairs. Now, I have, I think, 2 or 3 things that have been occupying my mind in a more abstract way these past few years. So the first one is I'm very practical, and we know that you don't achieve anything unless you define a clear objective. There is, lots of work in scholarship, economic scholarship, organization theory scholarship, psychology, law, and so on and so forth, that says that if you want to achieve something, if you want to deliver the function for which you've been programmed, you need to have clarity of purpose, right? And so my work on the consumer welfare is in a way the technical derivation of what I just said. A legal system, a legal rule, a legal norm cannot achieve much unless it is given a more or less precise objective. Or it cannot achieve anything if it's given more than one objective, because at some point there's always a trade-off, right? You're going to have to decide how you are going to subordinate one to the other, or how you're going to prioritize one to the other, right? So when we talk about multiple objectives, what we are talking about is a chain of hierarchy between objectives. There's no other way. It's not possible. And so the work on the consumer welfare standard is this. It's like, okay, it's nice all that talk about political antitrust and green antitrust and so on and so forth, but it's not helpful. If you've been working in private practice, if you've been working as a judge or an agency panel member, as I was in the past, the only thing that you're going to achieve is to give multiple objectives to a decision maker without further instruction or guidance, is you're going to increase discretion. Remember when we spoke about power in the beginning of the interview, we are talking about, antitrust has to be a bound on power. Maybe the way antitrust can be a bound on power is through moderation in the discretion of decision makers in the private and public environments. And so if that is the case, in the consumer welfare standard can be a good tool. So that's first thing. I also believe in this line which say that you cannot preach morals to empty stomachs. And so I think you got to start somewhere if you want to be more ethical or more principled or more political or more philosophical or more moral. And the base condition for intellectual flourishing has to be some form of material prosperity. And I like to think that antitrust can be one of the tools that we use to give people the means of subsistence needed to subsequently enjoy a fully stimulating intellectual existence, right? So this is my consumer welfare stuff. Is this like this very practical, one goal, define clarity of purpose, and material concerns first. That's one. The second thing that I've been working on is this what you call complexity. I don't know if I would today call this complexity. 2 years ago, I called this complexity when I was working with my friend Thibault. But this is this broader idea that there's lots of things that we don't. I mean, there's lots of things that we understand are going on around us in the economy, but we don't really find the good words to talk about this, right? It's not like the things we don't understand. These are things we feel and perceive as scholars that are interested in the empirical reality, and you can see a lot of activity around us in the economy. You can see a lot of activity in AI. You can see a lot of activity in cloud. You can see a lot of activity in cybersecurity. You can see a lot of activity in data centers. And yet, in the competition policy field, you see a lot of concern that there's not enough economic activity. That's, cloud is subject to anti-competitive dynamics, that Gen AI would be subject to anti-competitive dynamics, and so on and so forth. And so when you put these two things together, they don't fit. The empirical reality doesn't fit the perceived reality in, if you were, the sensible reality and if you use Plato, right? Sensible reality doesn't match really with the empirical reality. And that discrepancy keeps occupying me, because I think the reason why we don't talk about what we see in the right way, we have this inability to see this thing, is that we don't have the right concepts. And so maybe the concepts of complexity theory, the complex of innovation, so the concepts of literature fields like resource-based theory, capability theory, things that you find in the business and management science, can be useful channels to help us improve our connection with what's going on in the real world. I know, Olesh, have you been to the Silicon Valley yourself in your life? All right, if you go there one day, you will be astonished by the intensity and engagements and entrepreneurship that you find everywhere. It's not just like, around the Google campus or the Facebook headquarters. You can almost perceive, the dynamism in everyone, right? So of course, there's lots of things that are going wrong in the Silicon Valley, and I don't want to talk about the social and political problem there. But if you think about the economy, you just go there and you would just, feel it, right? And then you go to Brussels, you fly back to Brussels, and that was a few years ago. And you had people telling you, everything's going wrong. This is a monopolized segment of the economy. We have gatekeeping positions. So you would expect, output going down, innovation going down. And then you're like, but, 2 weeks ago, I was in an Uber cab with 2 young European engineers that were going to the Google I/O developing a developer event every year, and they were all hyped, and they're Europeans, by the way, and they were talking in the Uber about their projects, and it was their 3rd project in 5 years, and so you cannot square these things, right? So I mean, to me, this was the second thing. This is the second thing in my research. I want to square the sort of reality that I experience when you go to these places that are innovation clusters with the policy statement that we hear that there is a systematic problem with that segment of the economy.
This obviously, the question which the reflection, it would lead us to back to the beginning of the conversation. So maybe it will be kind of cyclical. So how to create this entrepreneurial culture, this drive, this spirit of entrepreneurship, which is so essential for innovation in Europe. We know that Silicon Valley is not the only model, it's not only the only place in the world, and not only the only means how to do it. I have also another question on your another yet incarnation. So if you want to reflect upon, basically repeat what you have said, or maybe add to what you have said about how to do it, or if not, then let us move on and look at your work at the European University Institute.
Yeah, no, look, there's not much I can add to what I said. You gave me the opportunity to speak a lot, and yeah, thank you again for that. I think, Europe, so Europe has, I think Europe has a mindset problem in a way, and it cannot be changed with competition policy, right? So we've lost a little bit this culture of entrepreneurship that we used to have. This optimism and the confidence in risk taking, and frankly, of course, competition policy cannot do much with that. It cannot do much to that. I think it, at the very anecdotal and almost trivial level of conversation, I would say I would like a lot of people to travel and go there, go to China, go to the US, and look a little bit how the levels of energy you have there. I mean, of course, in the US now, everything is a bit like weird and difficult. But, get a little more back into this mode of, being confident and building, not building rules and plans and policy programs. Not start from there, build stuff, and then let the policy people leave them a little bit on the side. Now we need policy in Europe, because I think Europe has a problem, which is we don't have a European labor market, we don't have one language, we have very different cultures, and so for us, the costs of bad policy equilibria are higher. In a way, the problem is the predicament is we need policy to solve the fragmentation and collective action problem we have in Europe. So it's hard to scale because we have these structural problems, not one language, various labor markets. So we need policy to unlock this. But at the same time, if policy gets it wrong, the costs are much higher because we have this fragmentation. If policy gets it wrong in the US, it's less of a problem because they have these structural advantages, the language, the labor market, the mobility is much bigger of production factors, much higher production factor mobility. So I think for us, it's a bit the difficulty in Europe, right? We need policy to solve big collective action problems and fragmentation, but at the same time, if policy gets it wrong, we pay a very, very steep cost.
Thank you very much, Nicolas. The question about the institution, which in so many respects shapes and represents the specificity of European intellectual establishment, European University Institute, one of 4 departments, Department of Law, which I had an honor to write my thesis, is being currently chaired by yourself. Tell us a little bit about the current situation of the Department of Law. What are the main changes you witness? What are the main what is the energy? Do you see this Silicon Valley of ideas, of legal theoretical ideas being flourishing there in this famous peripatetic fashion at the UI?
Yeah, look, I'm very honored to be the dean of the EUI Law School. So we call this head of departments, and the reason is, just like I said, I want to give my colleagues as much freedom as they want. So what I say about markets, I also almost apply it as head of departments. The department is a very decentralized unit in the UI where people do what they want. There's no central plan about the kind of research we should do, the kind of methods we should use, the kind of place where we want to be in 5 years. It's a very, very, very free, open-minded and tolerant place. And so, my colleagues do a very diverse set of things. Some colleagues are doing very sophisticated empirical legal work, Matthias Sims or Sergio Puig, for instance. Other colleagues are doing very important historical work, like my colleague Arnold Becker-Lorca, public international lawyer. I have other colleagues that engage in critical legal theory, like Martin Hesselink. I have other colleagues that engaged into law and technology. So this would be Thomas Trains or Deirdre Curtin, and myself, people working on the environment, John Scott. I mean, I've got, and I don't want to miss anyone. I mean, I'm going to miss some of them. Sylvia Suter, my other colleague, was doing constitutional law and feminist approaches to law. So it is a great place, very diverse. And the people that I work with have very broad interests. So if people want to do a PhD in law, not just in European law, international law, empirical, socio-legal, normative, the EUI Law Department is a great place. We cover a lot of ground and we're very curious. The only thing on which we have a lot of central planning, I would have to say, though, is that our PhD program is extremely structured, right? So in a way, it looks extremely structured. You'd say it's just minimally structured, but the base is that most PhD programs are completely unstructured, right? And so most of the PhD experience for most of the PhD students in law is, they're almost alone all the time, right? And they have to invent everything by themselves, right? So at the UI, when I say heavily structured, we are structured. There is a structure. It's not heavy. It's supposed and intended to help people complete their PhD within the 4 years. Sometimes it takes more than 4 years because you cannot predict how long research will take to reach interesting findings, of course.
And let me also finish this very informative conversation, Nicolas, with inviting you to provide your recommendations. We all in parem status in academic, we have this luxury of talking to each other freely, regardless of the normative positions, etc. So the recommendation should not necessarily be something pastoral, kind of mentoring, but some interesting observation maybe to academics. and also to students, what to do, what should not be done, and any other life hack, maybe work leisure balance, etc., which is necessary these days.
Yeah, okay. Um, okay, so I have a few. I have a few. Okay. So, the first one, of course, is you should read very broadly, not just in your field, but that I think everyone knows. And, if you're in this business, I would assume that you are a curious person. And so curious people tend to read broadly. So that's one. Second thing is, I would say, talk to everyone. And by this, I mean, just don't talk only to the people that are within your little or large group of experts. So what I mean by this is, if you're a young academic doing competition law work or whatever, I mean labor law work, don't talk only to university people. Talk to lawyers, talk to practitioners, talk to judges, talk to people in government, talk to NGOs, activists, talk to normal people that are not within the field. So I'm saying this because I've witnessed distanciation in competition policy between academics and the bar, for instance, right? And I don't think you can make any sense of competition law if you don't talk with the lawyers. Equally, I think there's been a sort of tendency to say, oh, the economists, so sometimes called the consultants, are, dangerous people. Some would say that. Other people would say, well, they don't have anything to say because they are basically talking what their client wants. Yeah, well, actually, it's true. They are talking what their clients want to achieve, but it's interesting to know what the clients want to achieve, because maybe, they should be listened to, because, maybe what they want to achieve is a good thing, or at least it's legitimate from their viewpoint. So if you're a big fan of being open-minded, I think you need to walk the talk and talk to people. Assume benevolence. I mean, assume interest. Of course, everyone's interested, but assume benevolence in how people go about their interest. Everyone's going to tell you his or her story, and there's nothing wrong about this. You should listen to it. That's the second. So I would say, yeah, talk to everyone. Third thing I would suggest is, do not obsess about your reputation. And this has become extremely important with social networks. I think people become very scared about what people will think about them. This is the enemy of free intellectual inquiry. So do not obsess about, if you're a competition lawyer, do not obsess about what, I don't know, the people in the agency are going to think about your work, but the lawyers are going to think about your work, what the people at the court are going to think about your work. I think maybe more to the point is, do not obsess about what people think about you more than your work, right? So this is maybe a better correction to what I was saying. I think people should be very careful not to obsess about what people think about them as individuals, right? Read the work and do not proxy people for their work. Do not obsess with that, right? Do what you think is right. Try to work seriously. So these would be, I think, the three things. Yeah. Read widely, talk to everyone, and do not obsess about what people think about you.
Absolutely. I think competition law bubble is known for being very amicable, despite of the very polar often relationship. With very few exceptions, we can say that still people manage to not move to the ad hominem level, and it's something which contributes to this broader competition culture, which is being nurtured, in particular in the EU, in Europe, let's say.
Yeah,
Nicolas
it's
Petit.
genuinely nice people. And this, I think this interview is in a way a good testimony to that, because Olesh and I, we tend to have, I think, divergent views on a bunch of things, including political antitrust, for instance. But even if that's the case, we've always entertained very nice and civil and amicable conversations. So yeah, I think this is a very good exhibit for what you just said.
Absolutely, I cannot agree more, and I'm sincerely grateful for finding time and for sharing your really insightful ideas and really important ideas. And it was great opportunity. Nicolas Petit, thank you very much for presenting your thoughts to all of us.
Thank you, Olesh, for having me. It was great.